My name's Carl Williams, and I'm with the American Civil Liberties Union of Massachusetts. And you'll hear some more about some of the work we've been doing in Massachusetts a little bit later from Matt Siegel. I'm thrilled to be here moderating this great panel. One of the things that I think is really important, and I'll make it a little bit personal and brief, is the stories of exoneration, the stories of innocence are powerful to people in the legal field. And I think they're even more incredibly powerful to people outside of the legal field, right? Because a lot of our comrades, a lot of law students, work in fields where if they explain their work to folks, their faces just glaze over. But anyone in this room, certainly anyone in this panel, can tell stories of innocence, tell stories of mass exoneration, can pick from dozens and dozens of those stories. And I think that is incredibly powerful in changing the systemic issues that we just heard about. Changing the systemic issues, changing the law about those issues, changing the process, getting access to data, and getting court decisions made that affect people's life for the better and change the injustices in the criminal legal system. So in that, I'm going to get right to these folks who are going to tell you some of those stories and tell you some of those processes from around the country. So I'm going to introduce Vanessa Antoun, who's a senior resource counsel at NACDL, the National Association of Criminal Defense Lawyers, Michael Mellon, who's with the Defender Association of Philadelphia, Peter Neufeld, with co-director of the Innocence Project, and Tara Thompson, who's a staff attorney in electorate law at the Exoneration Project, which folks heard about. And we're going to go somewhat down the line, and then I think Peter's going to wrap up. But we'll start off with some opening comments and talking about the projects and spaces that they've been working in terms of uncovering systemic misconduct and how to get what processes, what legal processes, and actually getting at the data in all of those structures so we can use that in our work locally and nationally. Oh, I'm sorry. Wrong order. I thought we were going to sit in order, but I guess not.
Good morning, everyone. For those of you who don't know me, I'm Michael Mellon. I'm an assistant defender with the Defender Association. And I'm going to talk about the role of defenders' offices in uncovering systemic misconduct. Defenders' offices, especially ones like ours, have a unique position since we represent so many criminal defendants from the beginning, and we are in a position to uncover abuses that maybe other organizations can't do because of that position we're in. At the Defender Association since about late 2016, I've been running the Police Accountability Unit. We are 2 attorneys, 1 stats analyst. We do proactive litigation to identify, catalog, and litigate police misconduct cases. And we train our attorneys to do the same thing. So to give you a little bit of background about the Defender Association itself, we are the public defender for the city of Philadelphia. We handle about 70% of the criminal cases in Philadelphia, which amounts to something around 40,000 criminal cases a year. And as far as it goes with PCRA work, we primarily don't get involved in that unless it is a max exoneration type situation. So historically, we have focused any sort of mass exoneration PCRA work on systemic misconduct that was from a reactive point of view. And it was, we would hear news articles or an officer got arrested or narcotics crew got arrested. A couple of the examples that were shown early on board were a result of officers being arrested or being investigated. And that's where our exonerations have come from. What we're trying to do now is take advantage of the digital age that we are in and figure out a way to capitalize on all of the information that we can collect in order to be more on top of these situations and identify them before we have to wait for the police to arrest their own. What we do in that case is we're trying to build police officer profiles. We take the information we have so we can create basically a biography on the officers that are in our department or in our city, so that we can then look at that and decide whether or not there is a pattern going on that we need to do something about. And that requires massive data collection. Currently, we're digitizing about 40,000 cases a year that are text searchable. We have notes of testimony for about like 300,000 cases, I think, that go back to 2000. And then we can track cases by officer, by geographic area, and by the client to see what kind of patterns that we can identify. And we've also decided to not only look at the stuff that we handle ourselves, that we have internally, but to look outside to connect the dots to what we think might be some sort of systemic misconduct. And so we've used in Pennsylvania what we call right-to-know litigation, or FOIA litigation, to collect more information on the officers that operate in the city of Philadelphia. We work to get civil settlement data, which is basically any time the city has to pay out money on a civil 1983 suit, we have a list of all the amounts, all the officers, the complainants on those cases. We take police officer employment arbitration information to identify officers that have gotten in trouble regarding misconduct. And then we can work back from there to then use that information to connect with an officer. We collect overtime data for police officers to see who's making more money, getting into court. The more money they make, there's an argument to be made that they're making more arrests, making false arrests in order to make more money for via overtime. And then the other information, most interesting information we got from Right to Know is that we litigated some, with the help of our appeals unit and Mr. Carl Baker, who's present here today, to get stop and frisk data for our officers since 2014, which amounted to 650,000 plus pedestrian stops and almost 1 million vehicle stops. That's lets us create a whole different profile on what these officers are doing for each and every time they stop a vehicle or stop a person on the street. Finally, we use PACER and go into PACER and we take civil complaints in there. We analyze those, look at over complaints of officers, see if there's a pattern to the complaints that people are filing in their lawsuits. And then we can cross-reference those back to the settlement data that we have to see what the outcome was and how much money was ultimately paid out by the police department, or excuse me, the city of Philadelphia. And you can also get some interesting information that's secondary to that. For example, our intern that was working on this a couple weeks ago found a document that listed every police-involved shooting for a 10-year period. It was an exhibit that the police department presented in a civil suit. It gave us the investigation number, the penalty for the officer, what the circumstances were, and frankly how many different officers showed up on the same list in the 10-year period, which was, I think, the most interesting part about that, besides the fact that there was very little actual penalty suffered by any of these officers in these police-involved shootings. And finally, in the city of Philadelphia, we've been fortunate enough, thanks to the press, and a right-to-know request that they did. Actually, it was not a right-to-know request, but like some interesting investigation they did. All of our Philadelphia police civilian complaints, summaries of these complaints are now online. And so it tells you what happened. It gives you the initials of the officer, the race of the officer, the district they work in, and the sex of the officer. So, and then the outcome of that investigation. So what that can do is, since we know who all the officers are, we can cross-reference that back because we're the defender's office and we represent so many different clients that we can figure out who the officers are that these complaints actually are related to. So the question is, how do we end up using that information to identify systemic misconduct? And usually, like with anything else, it starts with a client or a news article or maybe one random case that one of our attorneys picks up and looks at and says, this looks funny, and brings it to us. And I would say, for example, what we have a situation with a video that we got, and I'm sure criminal defense attorneys have either heard this or had this happen to them, where you get the video that shows that the officer lied about what happened. And the example I would use, we had a video of an officer who claimed they pulled the vehicle over for an inoperable brake light. Turns out not to be true. And historically, what you would do as a criminal defense attorney is you would litigate that case, that single case. You would either show it to the DA and be like, look, they don't have a basis for pulling this car over, you need to withdraw this case, or you impeach the officer. And then it would be over, and maybe Internal Affairs might be notified, and maybe they might sustain them, fairly unlikely, I feel like, and maybe that would be the end of the whole situation. But what we're looking to do is, how do we build on that information? How do we use that as a hook to identify maybe more systemic misconduct by those officers or officers in their geographic area? So what we want to do is we want to look up these officers, look up their other cases, see if this is a pattern that these officers behave in, if other people have had these same types of cases of getting pulled over and utilizing an inoperable brake light to justify the stop. And then we looked up the complaints in the Internal Affairs database that we have now connected into our own database, which lets us look and see if there's also complaints for patterns there as well to build on. And again, PACER, same thing. Has anybody made a civil suit on this? Have they won that suit? What was the outcome of that? And then we took our vehicle stop data and we look at the officers' vehicle stop data, what rate they stop people for similar violations, how often they search the vehicle, how often they ticket or arrest, how often they recover contraband, and then do they stop and search black and white drivers at different rates? And then, on top of that, to figure out if it's systemic versus the officers that you're looking at for that initial case, or if it's bigger than that, you have to do the same thing all over again for all their partners. But then, so what we're doing right now is we're hoping that this is something that a system we can use to build to identify systemic misconduct. Currently, at this time, we are with this example that I'm talking about right now, we are currently subpoenaing Internal Affairs records for all of these officers' partners related to these vehicle stop data based on the data that we've been able to crunch using the stats analysts that looked at that data and told us what all those various rates are. The last thing I just wanted to talk about real quickly is technology is really beneficial for when you're trying to identify the cases you want to use in mass exoneration. We have been able to use all of these different sources of information we have to put them into one single spreadsheet, if you will, identify all of the cases that look like they may be opportunities for reversals of conviction. So because with our IT department, we're able to take a spreadsheet, link in all of these notes of testimony, these PARs, what we call arrest summaries, the discovery on our cases, and create a list of all the guilty verdicts involving the problem officers. And then instead of having to go and dig all those files up and look at those to see what the outcome was, to see what the evidence was, we can actually try to streamline that and have it all right in front of us and just click a link and have it pop up. So it's been really beneficial for us to streamline the process with these new exonerations that we have coming down the pike with some new narcotics officers that have been recently identified.
That's great. Thank you so much. I have a million questions for you that I wrote down and I'm going to save for later, but things that I'm interested in. But with that, Vanessa, you want to talk to us a little bit about the work that NACL's doing?
Sure. Hi, I'm Vanessa Antoun, Senior Resource Counsel at NACDL, and I want to talk a little bit about the FBI microscopic hair comparison review that NACDL has been involved in, along with the Innocence Project, the FBI and the Department of Justice. What that review has shown thus far, some of the results of that review, and then also how it could be applied in a wider sense to state and local level examiners and also to different disciplines. So I'll just start out a little bit about how the review started. Some of the driving factors behind the review, in addition to the National Academy of Sciences report, was the exoneration of 3 men in the District of Columbia who were convicted based on faulty hair testimony by FBI examiners. Gates, Odom, and Tribble were those individuals, and that indicated, based on DNA testing, that the testimony by the FBI hair examiners at trial exceeded the limits of science. It was not the hair they said it was. That led, after negotiations with the Innocence Project and NACDL and the FBI and Department of Justice, to the FBI determining they were going to conduct a review of the hair examiner cases. One of the notable things about the review, and something that would be excellent if state and local jurisdictions were able to do this with partners, is the fact that the Department of Justice agreed to waive procedural objections and any statute of limitations objections in cases where errors were identified, to allow the individuals to litigate those cases on the merits. So that's one of the important things in conducting a review of this nature, not just to agree to uncover errors in cases, but to make meaningful notification and to allow opportunity for people to litigate that on the merits if at all possible. Unfortunately, that doesn't obviously apply to the states. It's advisory for the states. So thus far, the results in terms of states agreeing to waive those procedural objections has been, depending on the specific jurisdiction or the specific case. So the goals of the review were to identify the scientific errors and allow for the litigation. The review does not look at materiality, which is an important aspect of it, leaving it purely as determining whether the statements exceeded the limits of science, providing the notification, and then in that way being neutral and letting the parties determine what the next steps are. NACDL has been assisting people that are litigating the cases, but in the course of the review, we don't look into the materiality for purposes of determining what cases get reviewed or to have that affect the results. One of the other things I want to point out about the review is that the review did not look at the actual work of the examiners. In other words, what is reviewed is the testimony that was given in court or the lab reports, and to determine whether those statements exceeded the limits of science in 3 specific agreed upon error types. I won't get into the science aspect of it too much, but basically it's when the examiner states or implies that hair can be used to identify a specific individual to the exclusion of all others, or gives a likelihood or probability that a hair came from a specific individual such that it would lead someone to believe there is a certain likelihood or probability that can be determined, or when the examiner uses their experience working in the lab or the experience of their colleagues to bolster their conclusion that it came from a particular individual. In other words, we have no database, we have no way of showing how many people could have hair that look like this, but I'll tell you that in my experience, it's really rare that I see hair from 2 different people I can't tell apart. Obviously, over the years, the problem with those type of statements being they did not yet have the DNA technology to show that they couldn't tell hairs from 2 different people apart. They just didn't know it yet. So that's a little bit about the science. As to the results thus far of the review, the testimony we have looked at in over 500 cases, over 90% of that testimony contained statements that exceeded the limits of science by FBI hair examiners. So obviously that's a huge proportion of cases. It is over 90%, and what is also notable about that is the scope of the problem within the lab during those years. All of the examiners who testified, with the exception of 1, made statements that exceeded the limits of science. And we're talking about 28 people or more, not necessarily in the lab at the same time. The one individual whose one instance of testimony didn't contain scientific errors ended up still being wrong. The hair did not come from the person he attributed it to. So that shows that even if the testimony doesn't exceed the limits of science, there still can be other problems. The individual in that case was actually exonerated. That was Joseph Sledge in North Carolina. So that just shows that there are also other aspects to look at besides just the testimony. So the prevalence of the errors, the fact that it was systemic during this time, definitely shows that this is a type of effort that can be and should be undertaken in different jurisdictions if possible. We know that the FBI trains people in 48 states at their 2-week Hair and Fiber Academy. People can ask me and I can tell you what happened in your state. The FBI has given that information to us, and that doesn't account for other trainings they did outside of that Hair and Fiber Academy. traveling to places and training the individuals there. So it definitely leaves open the possibility that that type of error could have occurred to that extent in other jurisdictions and could have led to wrongful conviction. Thus far, as a result of, well, there have been 8 exonerations in FBI hair examiner cases thus far. The majority of those occurred before the review, but one case has led to an exoneration solely because of the results of the review, not DNA testing. The hair wasn't available. George Pratt in Massachusetts. So that was an example of a case where the review results, separate from any DNA testing, did really make an impact. In addition, as a result of this review, thus far 5 cases have been vacated. They're not exonerations yet. They might be. So although it doesn't seem like a stunning number at this point, as you all know, it takes a long time for these cases to work their way through the courts, and there are many in litigation right now. So those numbers do show promise for convincing other jurisdictions to undertake the same type of review. In terms of expanding this beyond hair, the other pattern and matching disciplines are definitely susceptible to the same type of errors. And at one point in time during the last administration, the Department of Justice had announced that it was going to essentially expand a similar type of review as what was done with hair to other disciplines that are practiced in the FBI lab, the Forensic Science Discipline Review. Thus far, those plans have been discontinued, which is a shame because they were going to go back and sample testimony from other disciplines susceptible of the same type of error and start to look at those cases and see what was there. Right now, to our knowledge, there are currently no plans to do that. What they are doing, at least at this point, is they're doing a prospective testimony monitoring program in an effort to seek to ensure that something like this doesn't happen again. They are also developing uniform language for testimony in reports, which, if properly developed, would be a step in the right direction to try to prevent these type of errors from happening and continuing, but it remains to be seen how the uniform language for testimony reports will be developed and what type of independent science will go into that. So one of the other things I want to bring up in terms of the scope of problems like this with overstating evidence, not just the exonerations that I mentioned from FBI examiners, but to date, according to our best numbers, 75 of the DNA exonerations from the Innocence project have been identified as cases that were involving hair evidence, not just FBI hair evidence, but state examiner evidence. Which brings me to part of the point of expanding this and using it to generate state-level action or local action to try to uncover additional cases. Starting a review in a state is definitely possible. Their former FBI director, Comey, wrote a letter to state governors asking them to take action where they could, explaining the problem, and that they should look into the actions of the labs in their state to see if some of these same overstatements were present, indicating that yes, they had been trained by the same FBI examiners that made these errors. So I want to talk for just a minute about starting that type of review or undertaking it. One of the first things people who are thinking about doing this or their organization is to try to find partners. And I would say that one of the important things is if you're able to at all to work with prosecution partners as well as engaging the lab. It is very important to get prosecutors and defense and innocence organizations working together on this. You can remove the materiality aspect and dispute that later, whether or not the person has a good claim that they're innocent or not. Should not be an impediment to investigating cases where there are scientific overstatements. Also, if you have prosecution partners on board, the notification could be more meaningful if you were able to get offices to agree to waive some of the procedural objections if there's error, and to have the cases litigated on the merits as the Department of Justice did. Right now, across the country, there are at least a dozen states and jurisdictions that are in some phase of doing their own review. And it's a huge undertaking. Arizona and Iowa and California, North Carolina and Massachusetts are some examples that have begun or in some process of doing a review. Some of the obstacles they have faced are, in addition to getting partners the funding, because a big objection to doing this kind of work and going through past cases can be whether or not there's funding. People have been successful getting some grant work on, lab and prosecution sides as well to do this. But some of the other good things that can convince people to join in is, the letter from ASCLD Lab telling the lab directors and individuals involved in this that they should go back and look and check, and that they have a duty to find out if this happened. Another aspect of this is to undertake this and send out a letter. People can litigate these cases without that notification, but if there is agreement as to what the errors are, and if there is a notification that bears some type of weight regarding a consensus opinion, it makes it more meaningful. So it has an additional weight beyond people picking up cases on a case-by-case basis. One of the big obstacles that has been encountered in the FBI review and can be encountered in other jurisdictions is identifying the cases. Peter and I were discussing that earlier. The FBI lab doesn't have good records going back much beyond 1985, which makes it more difficult for them to identify cases in which their examiners testified. They just don't know. A lot of those cases have come from the defendants or the defendant's counsel, and that's how they are found. But that is, I think, one of the critical parts that we have to address, not just in the FBI cases, but in any other state or local hair examiner case or state or local discipline. Any investigation to a state or local lab's potential erroneous statements is identifying the cases. So one of the ways to do that is obviously to get lab buy-in, but there also has to be a lot of outreach to find the old cases. Hopefully that, hopefully the FBI can serve as a model for some of the jurisdictions, their willingness to do that. But I will say in that review, it is, it's still a substantial, still a substantial obstacle to get some of those cases. There's a lot that can be done, so it's not, that's not to say it's something that should be a bar to anyone looking into this. One of the main lessons that came out of the FBI review is the government's acknowledge of the duty to correct and notify. So I think that can be translated into the work on any area of mass exoneration where the government has acknowledged that it does have a duty, not just to improve things going forward, but to look back at what it has done. If it has done something that isn't up to scientific standards, to correct it, but not just that, but to make a meaningful notification that can be used to get wrongly convicted people out of prison.
I'm just fascinated with that part. I'm going to have some questions about notification for you later, if I have time. But I just wanted to get to Tara Thompson and to talk. We heard a little bit earlier about the work of the Exoneration Project, but tell us what you're up to.
So I've been working in Chicago for about 10 years with the Exoneration Project, and as Professor Gross talked about earlier, my experience in these cases has mostly been looking for repeat patterns among police officers of misconduct that's led to problems in our clients' cases. And specifically, in Illinois, there is a state constitutional claim that you can bring in the post-conviction context. All the cases that I'm working on in this regard are post-conviction cases. And the claim that you're allowed to raise is essentially that you've uncovered new evidence that there is a pattern of misconduct by an officer that would change the outcome at your trial. And really where we're coming at in Illinois about this is something that's akin to Federal Rule of Evidence 404B, that you can show that an officer has, this pattern that would be admissible, or a pattern of prior bad acts that would be admissible to show their, plan, their intent, their absence of mistake, their MO. And so we're looking for essentially MO evidence that we can use to show that our clients ought to receive a new trial. And the context that we're coming at this problem from is we've got a client and we know that they are a victim of misconduct, either for our clients typically because a confession was coerced or because there are witnesses who were coerced or some pattern of misconduct along those lines, and we're trying to find other evidence of this pattern that we can use for our post-conviction petition. The other issue for us is, we heard from the Public Defender's Office talking about looking at this issue maybe more prospectively. We're always looking back in our post-conviction cases, and for some of our clients, we're looking at cases and patterns that happened potentially, 20 years ago, 15 years ago. So some of these officers aren't doing what they were doing in the past still. Some of them are dead, some of them are retired. So we're trying to go back and find evidence from the past. Some of the techniques that we used are similar to some of what Michael talked about, and I want to raise some additional things that we do in addition to that. And one thing I'll say is, we also rely on, media reporting about these issues, and I know we have a great panel later this afternoon about media, so I don't want to talk about that, and we'll save that to listen to them. A thing that I have found to be really important that I don't want to get lost here is that in many of these cases where you have police officers who were involved in working in particular communities, in Chicago, where you have detectives who were assigned to a particular area, who worked in particular communities, the community knows who these officers are, and they know about these cases. And I think, when we talk about uncovering systemic misconduct, well, maybe we're uncovering it for us, but, if we as lawyers are not members of the communities that we're working with, we're uncovering it for ourselves. We're not uncovering it for the community because frequently they know. So how can we as lawyers do a better job of communicating with the community to get the information that they have? In Chicago, we have this set of cases that involve this detective, Ray Guevara, who had a pattern of both coercing confessions and getting eyewitnesses basically to make false identifications or coerced identifications in order to get convictions. And lawyers worked on these issues for a number of years until finally I think we have come potentially in Chicago to some consensus that there's a problem with this detective. But there was a community organization that was started in the 90s called Comité Exigimos Justicia, and they've known about this for years. They weren't surprised that Detective Guevara was coercing people because they were a group made up of family and friends of people who've been convicted. So we as the lawyers needed to talk to them and get the information that they had because they had a list of people who were victims of this detective and they knew about witnesses and they knew things. So how can we as lawyers be credible sources for those groups to come to? How can we make connections with them? How can we find them? That's something that I think we as attorneys need to be doing a better job of doing, particularly for those of us who work with communities that we're not a part of. Some of that I think too, in terms of finding these patterns for those of us that are innocence projects or projects that have intake, is having good intake systems. And you heard from Eva Nagao earlier, who manages our intake, and she's doing some really great things with that process, which I'm sure she can talk to you individually about. But for us, we're also doing a good job, I think, of capturing and coding our intake, asking people where they know to identify the detectives or police officers involved in their own cases, and doing some internal data collection about that so that when we have something come up, we already have potentially a group of people who contacted us who also have those same officers involved that are potential witnesses for us or potential people that we can go talk to collect that information. I think frequently too, our clients may know. For those of us who have clients who are incarcerated, they may have come across people in the time of their incarceration that they also know to be, victims of the same officers, or, may have information if they've been communicating with people that they can share. And I think as lawyers, we don't want to lose sight of that either, that our own clients are sources of information for us. We're doing, and I think less well maybe than Michael's organization, the Defender Association, is doing with mining data from FOIA, mining data from civil litigation, and those are important sources for attorneys too. I think one thing that we're also starting to do in Chicago, and I think we can do better, is doing a little bit better job of communicating with other litigation groups and, crowdsourcing this among people that are doing the same work that we're doing, whether that's through our listservs. And I know that, Peter and Barry, and Peter may talk about this, doing a better job of collective databases that multiple organizations can access about this. That's something that I think would be a great idea for us in Chicago that we should be working on. But sharing information among each other is something that's going to be really important going forward, and something that we've done fairly well in Chicago in terms of communicating with other lawyers who are doing the same kind of work and figuring out who their clients are and what information that they have, what community groups they've been talking to. That's been an important source for us as well.
That sounds amazing, and I'm just going to sort of give you a primer. I really have questions about how we build that community connection, and maybe if you have some examples. So I'll get back to that if we have some time. Peter, you want to talk about how this is all working nationally, and not to but the databases, if the Innocence Project is working?
Paul, it's going to come up later in another section with Barry. What I wanted to sort of talk a little bit about is respond to what some of the people have said. And I think I actually sort of wanted to start with Sam's remarks to set this whole thing off, which is that when you look at his table 1, it's really fascinating that in these group or mass exonerations, you see a generalized statement that it was overwhelmingly black, largely black, overwhelmingly Hispanic. It would be extraordinarily useful if either the registry or Carl, you and Matt, the ACLU, could actually give us nose counts, hard numbers of what percentage of these people in these group exoneration cases or whatever you want to call the Massachusetts cases were black and people of color. It would be a huge asset to any kind of movement for racial justice. And I think, in that vein, why we need those numbers, there's a comment that Sam made when he said, well, and the Massachusetts cases are somewhat different because there it wasn't an actual cop who was responsible for the misconduct. It was the analyst in the laboratory. And we got to think about that for a second, because although it's the analyst in the laboratory, if in fact it turns out, as it appears, that in every one of these mass exoneration cases, the number of black defendants who were victimized by these police officers or forensic experts may be 95%, 98% people of color, then the fact that racial bias plays a role in arresting those people is itself misconduct. No question about it. And that misconduct needs to be addressed as well as what goes on in the laboratory. And so all of you who are doing these cases, if you can help us get actual nose counts, it'll really advance the racial justice movement. I think, it's sort of weird, because if we live in a country where if a bank teller is caught embezzling funds in a certain transaction, although there are less frequently bank tellers now, but in my era there were, and if a bank teller got caught, it would be an immediate reaction of the bank to do a complete audit of that teller's other transactions. No one in the bank would think, oh, this must be a one-off situation, and we may dismiss the person, but we're not going to do an audit. I'm on the board of a medical center now for 25 years. When I first joined that board, if the doctor had an unexpected result in the OR, we did not conduct an audit. That was the culture 25 years ago. That's all changed. Today it's routine that if we get an unexpected result in the OR, the hospital will do a very rigorous audit of those other operations to see what went wrong, how many times it went wrong. And it's not just out of an ethical duty to notify, it's for a whole bunch of different reasons. But unlike the bank, unlike the private sector, unlike medical centers, criminal justice almost uniquely fails to conduct audits when police or prosecutors in particular screw up, and in particular where the screw-ups occur in the most serious cases, the kind of cases that Tara was describing, homicides and sexual assaults. The other really revealing piece of data in Table 1 is that almost all these mass cases involve drugs, exclusively drugs. Some involve guns and drugs. but they're not involving the homicides and sexual assault cases. More typical of that would be a case we had in Washington that Vanessa referenced, the Gates case. And in the Gates case, there was a civil rights lawsuit that followed the exoneration, where we proved that the lead homicide detective not only perjured himself, but consciously, premeditatedly framed an innocent man by recruiting an informant and feeding that informant inside information to make him sound more credible. There was no question about it. At the end of the 1983 case, the Department of Justice decided not to prosecute him for perjury because it happened long ago, and he was no longer in the department. But there was no question that everybody involved knew it was perjury, and everybody knew he framed an innocent man. So we next contacted the U.S. Attorney's Office for the District of Columbia, asking them to conduct an audit. And they had a conviction integrity unit, and the conviction integrity unit said, we're going to do it. Without any kind of intermediate communication, more than a year later, we finally get a letter from the conviction integrity unit. And what they said is that their audit was done, that they reviewed 29 jackets of police files with the same detective was the lead homicide detective, and in their words, this review of the jackets failed to reveal either fabrication of evidence or the inappropriate use of informants. We asked them to give us the list of the names of the cases they looked at so the lawyers themselves could conduct an independent investigation. So far, they've declined. We've asked them for a more meaningful explanation of the depth of their investigation. So far, they've declined. And we know intuitively who've worked in the criminal justice system that an officer in a case that we've worked on and gotten an exoneration where there was a fabricated confession or somebody who was simply framed, okay, or an eyewitness was plucked from the street and set up to be an eyewitness against your client, we know intuitively that these are not one-off situations. That in all likelihood, because our clients are not presidents or movie stars or celebrated athletes, they're just regular people in the street, that the chances are pretty damn good that those officers did it again, and again. But nevertheless, getting audits in those situations where the cases are homicides or sexual assaults has been almost impossible. And there are three general ways of going about it. One way that's been discussed here this morning is to have the lawyers themselves conduct those reviews of large numbers of cases. Well, what you heard from Vanessa when they did it with Hare is, although the FBI cooperated initially in reviewing the testimony of the FBI agent, and the FBI acknowledged that in more than 90% of the cases, their agents got it wrong, that wasn't enough. You'd have to show materiality to reopen those cases. And that meant lawyers all over the country rolling up their sleeves and doing the very difficult work to get those cases reopened and hopefully those convictions vacated. It's the wonderful work that's done by the Exoneration Project in Chicago, for instance, or the People's Law Office on very, very serious cases. Nevertheless, generally speaking, with the exception of drugs, it's one at a time. It's extremely laborious. It's not mass exonerations. And we haven't seen that kind of change occur when lawyers do the cases. Perhaps, and this is the one bright light, when you talk about what you're doing in Philadelphia with a large database, that holds out some hope. But to be able to translate the efficacy of those large databases where they do indeed help individual lawyers who have a new case, and they learn that Officer Jones has a whole history, and it's going to be remarkably helpful and already has been in that regard, being able to translate those huge databases to have the ability to then go to the authorities and say, look, Jones has a pattern in practice. We think you should vacate all of Jones's cases over the last decade. You're a long way from that. Yeah. Okay, we're a long way from that. And, and I don't know whether or not district attorneys, quite frankly, have the wherewithal to ever do something like that. When the district attorneys have run these investigations, because they do, as Vanessa pointed out, have that duty to correct, they failed. Okay? The registry mentions 5 different mass exoneration cases around the country, and in each instance where the prosecutors were asked to do more than vacate the cases in this immediate cohort, they've declined. They said, hey, you bring us the individual case and we'll take a look at it, but they're not going to do it on their own. One small exception, possibly in Brooklyn, they said they would look at 70 cases by one detective, Scarcella. That was several years ago. So far, there may have been a handful of exonerations. It moves very, very, very slowly. In Virginia, recently, after we had an exoneration of a guy named Harwood, where the state serologist lied about the raw data, which excluded him, and testified that it was inconclusive at his trial, and he spent more than 30 years in prison, on their own, and they wouldn't do it in partnership. On their own, they've looked at dozens of cases, and they just reported to us, we see no similar fabrications in all of his other cases over 2 decades. But if we can't collaborate with them, if we can't share the data, if we don't have subpoena power, it's not going to happen. And even in the individual conviction integrity unit cases where there's agreement, where the prosecutor will collaborate with the local defense attorney, it's a far cry from seeing them do that with 30, 40, 50, or 60 cases at a time. We haven't seen that happen in the country. Which I think then takes us to the last approach. Once you talk about the problems of having lawyers do the work themselves or having prosecutor officers do it themselves, is the need to have some kind of third-party independent entity, whether it's a blue ribbon commission, a special master, somebody like that with subpoena power, who can collaborate with the defense attorneys to get the data and has the tools to get the data and then do something with it. But that's going to be a real challenge as well. We've done it 1 or 2 times. The results have not been successful. We're doing it in a smaller way in some of these 1983 cases, using the power of discovery. We have a case going on right now in Philadelphia where we had 3 primary bad actors who were detectives, and by working with the Public Defender Office and working with the Pennsylvania Innocence Project, we learned that they were also looking into other cases involving these 3 same detectives. We were then able to use subpoena power as litigants in a 1983 action to get the police files and DA files on all those other cases. We then collaborated with the Pennsylvania Innocence Project to have them review some of those files because they were looking at some of the same cases, and lo and behold, they find out that they were never given the Brady material that we were getting in the 1983 action for their own clients. But that's still small fry. We're talking about 8 or 9 cases working that kind of way. We're going to try something new, maybe in Chicago and Cook County, where we have learned, and it's sort of an unprecedented case in many ways, we have learned that a cohort of prosecutors in the 1990s played not a passive role, but an active role with homicide detectives to secure false confessions. No question about it. There are admissions by one of the prosecutors to federal agents, to federal lawyers. No question that it happened. What you'd want to do there is you would want to do an audit of that group of prosecutors during that period of time where their boss, who was the head of that unit in the DA's office, basically instructed them to submit themselves to the will and direction of those homicide detectives. You want to look at those cases. Now, maybe the Cook County State's Attorney's Office would agree to have a special master or some third party take on that kind of audit. We haven't asked for it yet, so we don't know what the reaction is going to be, but it's out there. The last bright point I'd like to mention is, even though we haven't seen it so far coming from any district attorney's office in the United States on this level, there is the possibility that the new district attorney in Philadelphia and the people that he has brought on will simply shift that paradigm, and for the first time we will see a DA's office able to accomplish that kind of mass exonerations in a substantive way with the most serious cases. So there is some hope. Thank you.
That's the quote. There is some hope. I'm going to hold that. So I'm going to ask you this, Vanessa, and it's absolutely done for completely selfish reasons. I just want to
Okay.
know the answer to this
All right.
question. So when we talk about notification, when it's, a dozen cases or let's say 7,500, and those people need to know, right, that there is an issue in their case, that there's evidence that's come forward, that there's something that's not dependable that happened in the prosecution of their case. How do you get to and notify those people? Who should be doing it, and what should they be telling them? Like, what's the that whole ball of wax there?
All right, well, first of all, I mean, it's hard. Even in the FBI review, as Peter can tell you, we have had arguments with FBI and the Department of Justice about the fact that they are positioned better than me and NACDL or the Innocence Project to locate people because, they're the FBI. And if they want to find someone, they can, but if they want to tell someone they messed up in their case, we had to motivate them a little bit more. I'm not saying there weren't good intentions, but it is a lot of work. And so in this review, the Department of Justice sent out the notifications with the official FBI results. And so they were tasked with finding last counsel because to clarify, the notifications went out in almost all instances to counsel, the last counsel of record, or a counsel that we identified and told them, like a public defender office or someone else, because they had an issue notifying defendants directly, not being able to know if they were represented and not wanting to undertake that to find out if all these people were represented. But that is definitely an issue. But in this review, the burden was on FBI and the Department of Justice. That's not to say they always got it right. There are a lot of counsel, they're not around, they're deceased. They're not practicing anymore, and they have to find someone else to notify, or we have to find someone else to receive the notification and then to let that individual know. So.
Right, and if that had come from the FBI, that might have been, if they found this long lost person, that might be an issue too. If that had come directly from.
Yeah, and I mean, there's also the issue that, in some cases, depending on the level of notification, do you want the FBI looking for someone who might have some other issues that they prefer not?
Call one little addendum, which I think is useful for the audience, which is that the National Commission on Forensic Science actually, by consensus, voted positively on a national code of ethics for crime laboratories. And the national code specifically, explicitly requires that the burden is on the laboratory where the misconduct occurs to notify every single individual who may have been adversely affected by this problem. And whether that means they go through prosecutors, they go through the police department, they have the ethical duty and they must do it.
Both incredibly useful. I'm writing those down, and I'm sure some other folks here are writing those down. And then I wanted to ask you, Tara, about, I had mentioned it, but building those, so getting that information, like you said, there are people who know this already, and you changed the name of our panel a little bit. You're sort of uncovering it for us, right? And I like that. So how do we build those relationships? What does that look like in communities that do, you said the Comité, I think, in Chicago, that knew about this stuff. How do we make it so we know, or maybe that we are those people who know?
Well, I think it's hard, and part of the reason why it's hard is because we don't represent those community groups. We represent our clients, and so we don't, you can't, I don't think we as lawyers can hold ourselves out as we're here to serve the needs of your organization, because it's not true. But I think that those organizations, first of all, need to know about what we're doing, and so there is some element of outreach that goes along with that, letting people know that we have a case that we've filed for somebody that involves a certain detective. And I think there are some ways that social media and other tools to let people know about what you're working on, where it's appropriate, leads to people contacting you, which has happened for our project. I think, too, some of that comes from being visible in your community. And does that mean seeking those organizations out, going and meeting with those people yourself, and again, letting them know generally what you're doing, where it's appropriate to do that, letting them see you as a person who, values and respects the community work that they've been doing, sees you as a person that they can trust to talk with about what they know. I don't think any of that happens, overnight. It happens because you as an organization are involved in the community, and those community groups see you as a resource for them and as a person that they want to talk to.
Yeah, and I'll just, so I'll answer my own question, but as a bit of a plug, thank you for that, is I think us physically being in those spaces, like, it's great to have a conference like this, but also, our communities have needs, right? And we're lawyers doing criminal defense work, doing civil work, and would like to see us. And it's a two-way process, right? Going there and talking to them, giving them, direct legal information, but also sort of on the backside of that, meeting those people, right? So I'm sure you could list a bunch of people in Chicago, I could list a bunch of people in New England who are the people who I think know those things. And maybe not today, but maybe tomorrow on when it's, we had our first drug lab scandal, then we had our second drug lab scandal, and now we have our breathalyzer scandal, and those folks, the more connected we are, the more they know. And I always think, and it's a mantra that I keep in relation to that, is somewhere in, let's just say in Massachusetts, for us at the ACLU of Massachusetts, somewhere in Massachusetts, there's some set of community people who know about a thing that would be so stunning to us, it would, maybe it wouldn't dwarf, but it would compare to the things that we're working on now, and we don't know them. And that always makes me say, we need to be out there. So thank you for that. And I wanted to ask you, Michael, about how you think, is there a way to sort of scale, and I think we're going to talk about this later, but I'm going to ask you about it now because we're the first panel and we get to do that. If we can scale creating a structure of a database or a set of database or a set of processes for everybody across the country in sort of tracking, I'll call it bad cops, maybe not the best term, but tracking bad cops or tracking bad behavior, and a way that we can build that not just in localities but across the country. Maybe that's a hard question.
Well, it is a hard question because I don't know the laws in the other jurisdictions are all different. But I mean, I feel like in Philadelphia, even if we weren't the Defender Association, we could use RighttoKnow to get a list of officers that operate in a jurisdiction. There is a way to do that. We've done that for different reasons, just to locate where officers might be. So I think there's a way to do that, at least with Philadelphia law. I know, with internal affairs, everybody's laws are different. I think in Baltimore, it's almost impossible to get internal affairs complaints. They got a pretty strong, okay, right. We are fortunate that it's less impossible, but it's still a lot of work to get that kind of information. But it's hard for me to answer that. But I would also say that to go to Tara's point about communities, we don't do enough of this, and I think we have to, as the Defender Association, figure out a way to communicate better with our communities. On occasion, I have gone out there because of something happening, and then as a result of that, get a million phone calls back after that because they're like, oh, you guys actually care. You're not just the public defender. You guys came out here and saw us in our own community, and we want to get back to you. So we have to figure out a way to use our resources to build those connections better, because it is something I've found in the limited time I've used it to be very, very useful.
Good. Thank you so much. And Peter, I wanted to, you mentioned the ACLU cases and race data. I don't know how we would possibly do that. I was racking my brain and thinking how we would do that, except from calling 200,000 people and breaking a court order also probably, because a lot of the information, the personally identifying information, is under seal. But have you other examples where people have gotten massive amounts of data and track that down?
Sure, you get, for instance, despite the best efforts of so many, last year in New York there were 25,000 arrests for possession of small amounts of marijuana on the streets of New York, and they have the racial data, and it shows how it was overwhelmingly people of color.
And that's coming from the police reports?
That's coming as a result of police reports and settlements and certain class action suits. And frankly, New York City police keep, it seems like, poorer data than Philadelphia keeps, okay, particularly on the stops and frisks.
Absolutely.
So, I don't think it's necessarily that heavy a lift to find out the answers to those questions, but it would be great if you folks in Massachusetts could figure out a way to do that. I'm sure the numbers are insane.
I'm certain that they are, and I would love to get them, and I'm still
Right.
trying to think of a way, and Matt's over there thinking of a way too. It might be impossible, but impossible things have been done in the past. I'm going to check in with someone who's moderating this, because I think we started late, and we're supposed to end in 4 minutes. But someone's going to wave to me and say whatever I can do. Great, okay. So I want to go out to the audience and see what you guys have, that's a lot, I think, and see what questions you have for folks, comments you have for folks.
Question. There was some mention of a waiver of the statute of limitations by the FBI. I'm wondering if the speaker could give a concrete example.
It's the Department of Justice sends out the notification letter and all of the cases in the FBI hair review. So, and I can email you and everybody a sample copy of that letter, but in the text of the letter, you know, through negotiations, it lays out that they will waive statute of limitations, procedural bars, they will raise no objection if they can't otherwise waive, and that's what the Department of Justice does. It's up to states, obviously, what they do, but the text of it is in the letter. In cases, there are, I mean, I know it has happened in some federal cases because they're complying with what the DOJ told them to, where in litigating the case, it was done so, I know some federal cases out in California, it was done so on the merits and not because they were raising objections to the procedural posture or anything. They went right to the merits.
Other, go ahead.
So this question's for Vanessa. When you were talking about that hair stuff leading to other aspects of science, maybe you had a second look for matching, did you mean like ballistics? Do you mean fingerprints? Can you talk a little bit more about that?
Yeah, tires, shoes, like you said, you know, tool marks,
Pretty much everything.
guns. Well, pattern and matching disciplines, because it's the same things that, like hair, where there's no way to say how many other people or objects can have the same, can look the same, or susceptible of the same type, potentially the same types of overstatements, where lacking anything concrete to say, yet wanting to convict someone, you start pulling from your own experience. Well, you know, but hey, I'm going to tell you, we don't have numbers, but I know it's really rare that you see this, and they look to other non-scientific ways to bolster what they want to say to get where they want to get.
You should also know in that regard, because I worked on that hair review with Vanessa, is that the Justice Department had decided to do what was called the FSDR, the Forensic Science Discipline Review, where they realized that these other disciplines that you're mentioning involving pattern and impression and trace evidence would have the same kind of vulnerability, that they would do reviews of a random selection of transcripts over the last decade. And that was supposed to start last spring. And all the kinks were being worked out, and then finally, after the last election, the whole review of the other disciplines was suspended permanently. So they're not going to do it on their own. It's going to only happen if lawyers like you take it upon yourselves. But there's no question that all the same problems apply.
Sure.
Is it a question, Peter? You were mentioning subpoenas in 1983.
I'm sorry, could you speak up a bit?
Sure, you were mentioning subpoenas in 1983 cases, and I'm wondering how you justified it. Like to a district court, I'm sure the DA or the police would have objected to the subpoenas. So I'm wondering, was the justification in support of a Monell case?
So there's two
I'm just going to repeat the
Oh,
question
sure.
because we have a lot of people that are not in this room. So subpoenas in 1983 cases, and how did you deal with objections to that?
Right, well, so I think actually what he wants to know is how do we use discovery to get all these other files involving the same cops in other cases. So there are two ways. One is there is a Monell claim in these cases, and a Monell claim, for those of you not familiar with it, is actually against the institution itself, saying that there's a pattern and practice of some kind of constitutional violation. To show the pattern and practice, you want to see how these same cops have done in other cases, and there's been no discipline of them at all. The second reason is we're doing it for the grounds that Tara described, which is 404B. We're looking for other examples of the same kind of misconduct so we can show in our case that it wasn't simply a one-off situation, that it was the officer's MO. And so we were able to find other cases for each of these detectives in Philadelphia that met that criteria. And then it became even strengthened by our collaboration at that point with people from the Pennsylvania Innocence Project. And we've not had difficulty in other cases with judges granting that kind of discovery.
Sure.
Sometimes subject to a protective order, but at least you get it.
Just a comment about the connecting with the communities. One of the things that Philadelphia has begun are participatory defense hubs, and it's really been supported by the chief public defender here. And even though they're taking on individual cases, it is really engaging the community involved in learning very much how to manage the justice system and defend someone that they know. And I know that the chief public defender has been coming because I've been in the trainings, and I think it's a good way for the legal profession to engage with the community, because that's where you will actually be able to hear what knowledge they have of what's going on in their particular area of that community.
So just for folks, so the comment was more of a comment than a question, but about participatory defense, and I'll just say there's an organization in California, which is strangely, it's called Silicon Valley Debug, which sounds like a tech firm, but it's not. Maybe they're debugging the criminal legal system. And there's a youth organization in New Orleans, which is called Rethink, which uses that same model of participatory defense that is bringing people in from the community, non-lawyers in from the community, to build like packets of information about someone's, whether they go to synagogue or mosque, whether they, tutor children, whether they have pets, pictures of them as children, and building these packets to assist public defenders and criminal defense attorneys in bail arguments, in probation surrenders, in appeals, to humanize human beings. And then when people do it the first time for their loved ones, then they come back and do it for other people and continue that process and teach people in the community, and people have been very excited. I just met a 17-year-old from New Orleans who did it and was like, this isn't going to work, it won't work, and was fascinated and is now like absolutely obsessed with doing it all the time. And did you have more on participatory defense? You look like you were ready to. No. But it's a great model and people should check that out. And someone should tweet that. You want to I think we have time, over time, but I think we probably have time for at least one more question or comment.
I want to say something about the information we have on race in response to Peter and other people. We have information on race in some detail for some of the group exonerations you see. For example, in particular in Tulia, we know the race of everybody involved. They're all African American except for I think 2 or 3 whites who were either married to African Americans or lived in the African American community. In Benton Harbor, I believe we know the race of basically everyone. I think maybe 1 or 2 of them were white. The larger ones, less so. There are 2 separate patterns. One you see in cases that I haven't mentioned from Harris County, Texas, we have a whole bunch of people who pled guilty to drug crimes and were then exonerated by lab tests that were conducted after they pled guilty. A majority of them, 60-some%, are African-American in the city that's about 20% African-American. That's ordinary workaday discrimination in drug and law enforcement. We talked about this on the way over, right? African-Americans, whites, Hispanics all use illegal drugs in the United States at about the same rates, and the rates of arrest are hugely different. And that's reflected in routine errors that occur in those cases. As far as we can tell, most of those people pled guilty because they were being held in pretrial detention, that was the quickest way to go home. And then there are the scandals where police officers abuse their authority and focus in on particular groups and victimize them. And there the focus on minorities is much stronger. There it gets up to, as far as we can tell, it gets up to 80%, 90%, 100%, things like that. What you'll see in Massachusetts, if you get real racial data, my guess would be something like a majority, but not 90%. There's just ordinary.
I want a number of a prediction. What do you got for me?
But it can be a lot more than the percent of minorities in the population, and a lot more than the percent of minorities among drug users.
And a lot more than the percentage of blacks even in the corrections system.
Yes, probably.
Yeah.
I think that brings us to a close. Thank you guys, and thank all of you.